class is one that has a professional approach. I have looked at other classes in media law. Some of them I think are good to prepare you to be a law clerk or maybe a fledgling law student, but it doesn't help you much with being a media practitioner because the other classes are all retrospectively based. What I mean by that is this. At the end, when your boss is writing a check to the successful plaintiff, you'll be able to turn to your boss and say, oh, hey, this is why the plaintiff won. These are the dumb things we did that, on reflection, I see. Well, that's not helpful. So the professional approach is aimed at giving you the tools so that you can spot these legal landmines before you or your boss steps on one. The class is also built around the notion that you should know what your rights are and how to assert them. And finally, and regrettably, in some cases, you should know when to simply shut up and walk away because you're going to get in trouble if you don't. Passing the class, well, here are my recommendations. Number one, read the textbook. You have the list of the cases and chapters we'll be covering. After you read the textbook, watch the lectures, then read the textbook again. It'll help you to understand what's going on. You might just watch the lectures and then skim through the textbook, but that can cause problems because the lectures for most of you are going to be in a slightly different language. We will be using legal terms, and some of the concepts may be foreign to how you think of the world. After reading, watching, and reading again, you should blog your questions, your observations about being a student, observations about life and popular culture, and comments to me. If, in fact, you see something in the news that makes you question how the law operates, send that along in a blog, and I'll respond to that. On Fridays, I will do a separate YouTube video answering your blog questions or clarifying things that you're not clear on. So keep an eye out for those. Lectures on YouTube, you'll get the URLs. The grades are based upon the exams. You can lose points if you don't blog. You don't get any additions for doing your blogs. It's simply a part of the obligation of the class. You can expect the essay exams in the 2nd, 3rd, and 5th weeks. The exams are built around hypotheticals. You'll get a fact pattern. And these fact patterns in pretty much all cases are based upon real life. Some of the fact patterns I change considerably. Others I simply alter the names to protect the guilty. Now, you'll look at the fact pattern. You'll figure out what the problem is, and then you'll write how to deal with it. You'll resolve the issue that presents. The legal issue, well, this is one of those things that you may not be familiar with. You have to understand that in real life, you get no warning that you're about to step in it. There is no guy who walks around waving a red flag and ringing a bell saying, hey, you're about to be sued. You find out after you've been served with the complaint. So in this class, I'm hoping to teach you enough about the risks out there so that you will spot trouble before it happens. And of course, trouble can include being arrested, being sued, losing your job. So stick with me and I'll hope to prepare you for life as a practitioner. With that in mind, let's go over a sample question. Now, this is a question that I've used in classes in the libel and privacy sections, and I'm going to walk you through this to give you an idea of just how complicated things can be. So our sample question deals with Judge John Jameson. He's from Oklahoma, been a judge for a while, been elected and re-elected, and the story we're dealing with in our hypothetical is one that was published earlier this year in Oklahoma City. Now, I've put the fact pattern in Oklahoma. In this sample question, the state has no consequence in how you look at the case. So here's the story. Headline reading, of course, the judge's truck being seized in a drug raid. The story that refers to the pickup truck that's registered to Judge Jameson. It's been seized. They've arrested some people. They've got more than 500 pounds of marijuana and some guns. And the last paragraph of the story refers to the fact that some of the marijuana was discovered in the back of the pickup truck that is registered to Judge Jameson. And what makes this story interesting is that Jameson has a record of being tough on drug crimes. The story ends with information that Jameson couldn't be reached for comment before publication, even though the reporter made several calls and sent some emails. So those are the facts. That's what you're dealing with. And this is a fairly simple sample question. So the stories come out. Judge Jameson comes to see you because you're enrolled in Journalism 302. He tells you these things. Jameson says that he sold his pickup truck a couple of weeks before the raid, and he sold it to Andrew Dice, who was one of the people arrested. Jameson listed the truck in the classified section of Bob's list, and Dice responded to that. Now, Bob's list is analogous to other online classifieds. Jameson has proof of the ad and the bill of sale. Jameson says, well, it must be that Dice didn't register the truck under his own name. And Jameson, of course, says he's never been involved in anything illegal, much less drugs. You know the reporter, and she's told you that she traced the ownership of the truck through state motor vehicle records, but because she doesn't trust you that much, she doesn't tell you anything else. So here we are in bold, the questions you're going to be dealing with. What lawsuit or lawsuits can Jameson file? This is where you spot the issue. Who will win and why? This is an important thing. There are some times when you'll run the risk of being sued, but it doesn't mean that you will actually lose. So just be aware of this. Pretty much all questions I include C, telling you to be detailed and show your work. It's kind of like answering or solving quadratic equations. You have to put all the steps down on the page. Otherwise, the professor doesn't know if you know the law. So do that. Go through every step. Even if you think, as in solving quadratic equations, that x equals 7, go through all the steps of the quadratic equation. Because when you're out there as a media practitioner and you see something that is going to jump up and sue your boss, you need to explain to your boss what the problem is, and you need to explain in detail what could go wrong. Here, think of this as a practice run-through. In doing so, I want you to cover all the bases, even though you think that the suit could be disposed early on, because you won't get this very same fact pattern in real life. And of course, at the end, I also tell you that you cannot create any additional facts. So you can't come up with a surprise fact that would resolve the case in your favor or against you. This is not like Matlock, a TV show that your grandparents or great-grandparents used to like to watch. In that show, Matlock, played by Andy Griffith, would, in the trial itself, produce a surprise witness, and the real bad guy would admit everything. That doesn't happen, and you cannot Matlock your way out of a case. Because this is complicated, I recommend using something called IRAC. It is a method for understanding lawsuits that's employed in law schools, and the I in IRAC is the issue. What's going on here? What tort is at hand? And of course, you remember from the Liebeck video that torts are civil wrongs as opposed to criminal acts. The R is for rule. What's the rule that applies to each tort? the A for application, how you apply the rules to the facts, and then conclusion, who wins and who loses. Now, you win, the other guy wins, that's worth the least number of points on my exams, because you could simply toss a coin and you'd have a 50-50 chance of being right. The weight of the exam comes first from the issue as the most important thing to get right. And let me tell you right now that you need to be on top of the lectures and the readings. For my in-person classes, students may not have read the textbook before they come to lecture. They'll sit in the lecture because they haven't read the textbook. They're not really familiar with what we're talking about. They'll take down a few notes. They may, after lecture, skim through the book, and then they come to the exam. My exams are open book. They are open book because in real life, I want you to be consulting references. I don't want you simply to guess at things. Now, you should know enough about the law to be able to tell your boss this is a prior restraint issue, or this is an issue involving access to records or covering criminal trials. You should know enough to do that. But then you should also know enough to look for references that will explain what's going on. Getting back to the student who hasn't read or paid much attention, that student will see a word in the fact pattern, and it will ring a bell. Oh, I've seen that word before. They will assume the question is about the issue based upon the word, and then they set off to write a really amazing answer to a question that is not on the test. As a result, they wind up with 0 points. So spotting the issue is an important thing to do. Now, the class is broken down into 3 segments. The segments cover a limited number of topics, so it should be fairly easy for you to figure out what the issue is, but do be careful. Here, we're dealing with a libel case, and we're also dealing with a false light invasion of privacy case. Both libel and false light are torts, civil wrongs, and you saw in the Liebeck versus McDonald's video. In this case, someone will say, you caused me harm, and then I'm going to sue you for compensation. So, we've established the issue, libel and false light. Now let's take a look at the rules. A libel plaintiff has to prove 5 things. I call these the 5 fingers of libel. If you only have 4 fingers or 3 fingers, you don't win the case. You have to have all 5 to prevail. The first finger is publication. Somebody besides you and the person you wrote about or broadcast about must have seen or heard the offending publication. Second, identification. The plaintiff, the person suing you, must have been identified in the publication. Third finger is defamation. Now, I know that in casual conversation, defamation and libel are pretty interchangeable. Here, I'm using defamation as a term of art to refer to the third element of libel cases. For a statement to be defamatory, it must be wrong and false to begin with. It has to be wrong, it has to be false. If it's true, then it's not defamatory. It may harm the reputation of the plaintiff, but if it's true, well, that's the plaintiff's lookout. Fourth finger is damages, and we will not spend any time on damages. We leave that up to the lawyers and the forensic accountants. The fifth finger is one of the most important, if not the most important, is fault. The First Amendment requires that the plaintiff in a libel case prove that the published defendant was at fault in publishing the offending statement. So, libel plaintiffs have to prove all 5 fingers, 4, 3, 2, or 1, and you get nothing. Let's take a look at the application of the rules to the facts. Publication, it was published. We know that because the fact pattern says it was published in the newspaper in Oklahoma. People other than the judge saw the story, so publication is present. Identification, the story named the judge. He was identified. Then we come to the third finger, defamation. The first question you always have to ask yourself is, was the story false or wrong? Here, the story was true. The story said the truck was registered to Judge Jameson. In fact, at the DMV, the records show the truck is registered to Judge Jameson. It doesn't matter that he sold the truck to Andrew Dice. The registration has not changed, and the story simply says the truck is registered to Jameson. That's the truth. Damages, we'll leave that to the lawyers. Understand, though, that some states require the liable plaintiff to prove that he or she suffered an economic loss in order to move the suit forward. And then fault, well, we have two kinds of fault that two different types of plaintiffs must prove. Regular, ordinary people pretty much like you or your neighbors or your classmates, only need to prove that the statement that was offending and defamatory was published negligently. Negligence is defined one of two ways. You're negligent if you fail to do something a reasonably prudent person would have done. You also can be found negligent if you do something that a reasonably prudent person would not have done. Proving negligence is easy. Pretty much I tell students, if you got it wrong, you were negligent. And I can say that because, number one, the case doesn't go to trial unless it was wrong or false. Now, if it's wrong or false, that means the truth is out there somewhere. And all you had to do was do what a reasonably prudent person would have done to find that truth. And conversely, the fact that you published the false statement means that you did something that a reasonably prudent person would not have done. You have to understand that in a lot of these cases, you're going to be before a jury, and the jury will be blessed with 20/20 hindsight. The plaintiff's lawyer will have shown the jury how easy it was for you to have found the truth, and so pretty much you get it wrong and you have a regular person, negligence will be found, and you're going to be out of luck. Now, the other category of people is for public officials, famous people. Those guys have to prove that the statement was published with actual malice, and I'll explain actual malice. But people like Beyonce, Donald Trump, Joe Biden, well, they're in the category of people who have to prove actual malice. Actual malice comes to us from the 1964 Supreme Court case of New York Times versus Sullivan. We'll spend a little time talking about that later on in the libel section. So, Judge Jameson is an elected official. He has some fame or notoriety, depending upon what side of the law you are, through his job, through the fact that he's been elected and reelected. As a public official, he must prove actual malice. Now, here's one of the things when I talk about terms of art. Terms of art means that the words don't mean what they would mean in an ordinary conversation. So actual malice here as a term of art does not mean hatefulness. It means that one of two things has happened. The first, the publisher has published the story knowing that it was false. That's actual malice. Or, alternatively, the publisher published the story with reckless disregard of the probable falsity of the statement. It's complicated, and we'll spend more time going on over that in the libel section. So, reckless disregard, you can understand it this way. When you look at the facts, you can see that objectively, it should have been clear that the story the publisher was publishing likely was false. Now, it is much more difficult to prove actual malice than negligence, not that negligence, and it makes it harder for famous people or elected officials to win libel suits. Here, there is nothing to indicate that the publisher entertained thoughts that the story was likely to be false because, in fact, it was true. There's also no indication that the publisher published the story knowing it was false because, in fact, it was true. So the judge is going to lose. He's going to lose two different ways. Now, even though you might stop your analysis with third finger defamation, I still require that you go through all five because, as I said before, you're not going to get the same facts in each separate life instance. So you have to go through the complete analysis. I'm involved with libel cases from time to time, usually as a consultant, occasionally as a defendant through my work in media. And it's a matter of going through the whole case and winning as many ways as you can. That's what you go for. It's the belt and suspenders rule. You make sure that you have everything covered, and it avoids embarrassment. So our conclusion, Jameson loses, the story was true, and he could also not prove actual malice. Well, that's a whole lot to go through, but we're not finished because we have the false light claim. False light is a privacy tort. Privacy torts are based upon the notion that we have the right to be left alone. And false light, one of the 4 privacy torts, we'll get to that when we get to privacy, is at its most basic lying about somebody to the public. A false light plaintiff must prove 4 things. The first is publication and identification. This is similar to libel, but in false light we put the 2 together. It must be published, it must identify the plaintiff. The second finger is that the story must be false, it has to be wrong. The third finger is offensiveness. The falsity must be offensive. Now, it's not to say that someone will say ew when they see the story. It's that the jury will find it offensive that somebody lied about somebody else. And the fourth finger is fault. False light requires actual malice for all plaintiffs, regardless of whether they're ordinary people or famous people or elected officials. So that's the rule. We have the issue, false light, we have the rule, the 4 fingers. Now we're going to use the application of the rule to the facts. Publication and identification. We know that the story was published. We know that it named Judge Jameson. Falsity. The story was not a lie. It was true. There is no falsity. Because there is no falsity, it can't be offensive. Now, you could make a common sense argument. Well, it's offensive that the judge's name is in a story about drugs. We're not doing common sense, ordinary conversation. We're doing the law. And because the story was true, the jury cannot find it to be an offensive falsity. And then fault, as we looked at in our application of fault, actual malice, there is no way for the judge to prove actual malice because the story was true. So yes, it is complicated, but if you use IRAC, it'll help you go through each step and helps make the complicated process manageable. Also, work with me. Ask questions through your blogs and in emails. Phone me if you have something. I will post your questions and comments, and then I will answer them. And don't be afraid to ask something. I tell students in the in-person classes, I ask them, anybody who had a nice teacher, a nurturing teacher who said, there are no dumb questions, raise your hands. And depending upon the year, sometimes I'll get more hands, sometimes I'll get fewer. And then I turn to these students and I say, your teacher was wrong. There are dumb questions. The dumb question is the question you have and do not ask. Anything that you do ask is, by definition, not a dumb question. And it's nice if you ask the questions, because if you have the question, probably 2 or 3 of your classmates have the same question, but they are too chicken to raise their hands. Go ahead, ask. The worst thing that can happen is I shoot you. And I have not shot people a glare for decades. Media and the law. Well, you have to understand that the law is a part of everything in society, including those of us who are media practitioners. So we can be arrested and prosecuted for breaking a law. We can be sued if we injure somebody, and the people we injured can be people or they can be corporations, because after all, corporations are people too. Just ask the Roberts Court. We also can be subjected to injunctions. An injunction is a legal order from a court to prevent us from doing, quote, bad things. bad things are in quotes because what some people think are bad, other people think are really good. We can also use injunctions through the application of writs of mandamus to force the government to do its job, for example, to make public records public. We also are subject to regulation by different federal agencies, could be the FCC or the FTC. So we are intertwined with the law. We cannot disentangle ourselves from it. How laws work? Well, we've got crimes, we've got torts. Crimes, the states decided that certain activities are harmful to society, and so they prohibit the activity. Not only do they prohibit the activity, but they say, if you do this thing, we're going to punish you. And the state can do so only after a judicial proceeding in which the defendant is given due process, the protection of the law. The two elements of crime, actus reus and mens rea, you're going to see some Latin terms through the course. Latin because we're dealing with the law. And lawyers, of course, know that we should use Latin because it helps justify the $950 an hour that we are charging folks who don't have law degrees. The actus reus is the act itself, the thing that the defendant did, that the state says, no, you can't do that. The mens rea is the criminal thought. And most crimes, especially serious crimes for which you can go to prison or be put to death, require that the state prove a criminal intent to do the bad thing. The exception is for strict liability crimes, and strict liability crimes give liability without having to have an intent. For example, if you overpark at the meter, or if you park in a no parking zone, or if you speed, your act is all that's needed. The state does not have to prove in court that you intended to overpark at the meter or that you intended to speed. And be careful about that. Sometimes students who learn a little bit about the law will try to apply that to the real world, and the results are not funny. Criminal procedure, of course, we have notice. People have to understand what is illegal. If there's no notice, then you're dealing with an ex post facto law, that is to say, a law that is created after the fact. But be careful, this doesn't mean that you can commit crimes and then say, hey, I didn't know it was illegal. Notice of crimes is applied as a general principle. You don't have to have read the statute to know that robbing a bank is against the law. So ignorance of the law is no excuse. Ignorance of fact, however, can be an excuse, and we may get into examples about that a little later. So, first, there are laws, people are aware of them, like don't rob banks. Second is the conduct that the state says is criminal, so because you have tuition bills to pay, you go and you rob a bank. That's not a good thing. Then you get arrested, you go on trial, you go through the appellate process if you have enough money. If you don't have enough money, it ends when the judge hands down your sentence, which means you could wind up in prison or jail, 2 different places. And of course, you have seen enough of popular culture. You know that the prosecutor has to prove the elements of the crime beyond a reasonable doubt. Now, if you weren't in debate or mock trial in high school, you may not have thought much about reasonable doubt. But, simply put, it is you come to a conclusion as to the innocence or guilt of the defendant based upon reasoning through the facts and having no doubts about that finding. Torts, well, civil wrongs as opposed to criminal acts, and they occur when one person or entity causes harm to another person or entity. So, entity because we have corporations, businesses, and they can commit torts just as well as people or other people. Now, you should understand that sometimes what you do can be both a crime and a tort. Trespass is a prime example of this. If you trespass onto the property of another, you can both be charged with a crime and sued for the tort. There is no double jeopardy, and you could wind up going to jail as well as paying damages to the person whose property you trespassed on. In civil cases, the standard for finding for one side or the other is by a preponderance of the credible evidence. Again, those of you who went through debate in high school, or you know people who have done that, and this is not a patch on people who participated in debate. I participated in debate in high school. Well, maybe that accounts for what I'm doing. Anyway, people who are highly technical will say that preponderance of the evidence is 50% plus 1 scintilla. But it's not that way for real. I mean, think about the decisions that you've made in your life. You have never made a choice that was 50% plus 1 scintilla. And the same is true in jury verdicts in civil cases. No case has ever come down to 50% plus 1 scintilla. There's always been more for the winning side. When we're talking about civil cases, you may as well understand my maxim of the civil law. It is pretty simple. Any fool can sue any other fool over any fool thing. For example, you go to the hardware store, you buy a can of spray paint, you look at the label on the spray paint can and you'll see a warning. It says, hey, don't point the little hole in the top of the can at your eye and press down on the button to see how all that paint comes out of that little tiny hole, because you'll spray paint or shellac your eye. These warnings come to us as a result of people doing dumb things and then suing. They won't always win, but the cost of defending a suit is such that a lot of institutions, a lot of businesses, a lot of industries will take precautions to help keep people from hurting themselves. And you might say, well, this is the nanny state. You know, we've got people protecting us from things that we don't need protection from. And that's one point of view. On the other hand, we have things like airbags and seat belts and steering wheels that don't spear people through the chest when they're involved in a head-on collision because of lawsuits and the threats of lawsuits. It used to be, if you had a car in the old days, that the dashboard would be made out of metal. There were no airbags. And if you were in an accident and it was a pre-seatbelt car, you would stop moving when your head hit the dashboard or went through the windshield, which in those days was not made with safety glass that would break into 1,000 harmless pieces. So we are the beneficiaries of lawsuits. And occasionally I will tell my in-person classes about lawsuits over spring formal dances in law school. You'll have to send me an email. I'll explain it to you. So, if you run across someone who says there are too many lawsuits, too many plaintiffs' attorneys, think of the Liebeck cases, or the Liebeck case. McDonald's used to sell the coffee so hot you couldn't drink it. I used to work at McDonald's when I was in high school. And what would happen is some old guy would come in, buy a cup of coffee, and then ask for ice. And the old guy would take the lid off the coffee, put the ice in the coffee to cool it down so that he could drink it. Well, McDonald's doesn't do that anymore. Remember, in the Liebeck case, they established that there had been 700 cases of people complaining about being burned because of the hot coffee. So, lawsuits can help us. They help to eliminate some of the risks that are out there. Let's move on to the text. We're talking about freedom of expression. Here's where you should probably be taking notes. The First Amendment, it is, of course, the foundation for what we're dealing with. And you all know what the First Amendment says, 47 words starting with Congress shall make no law. The First Amendment was not present at the beginning of the country. Initially, the country operated under the Articles of Confederation. We had just fought a revolution to overthrow a highly centralized system of government, the English monarchy and parliament. So when we became independent, each of the 13 colonies, which were then states said, we'll work with each other, but we're not going to have a strong central government. We will be confederates, and we'll operate under the Articles of Confederation. Well, the Articles of Confederation had some problems. One of which is there was no chief executive. There was a committee which was rotating. In other words, they'd have representatives from different states on this executive committee. And if you've been in any committees, you'll know that they are not always the most efficient way of working. There was no taxing authority. The central government, such as it was, had to rely upon the generosity of the individual states. And third, and most importantly, there was no way to resolve disputes among the states. So if New York and New Jersey were squabbling about a piece of land, who owned the land, who got to control the revenue from the land, there was no central government they could turn to in order to resolve this. And disputes between states got kind of serious. There were some instances in which militias from one state would shoot at the militias for another state. And the country wasn't working the way people thought it would. So they sent delegates from all the states to a convention to amend the Articles of Confederation. They got there, they took a look at the articles, they took a look at all the problems that had arisen under the Articles of Confederation, and they said, this is not going to work. We can't mend this. We can't patch this. So instead of a convention to amend the Articles of Confederation, they had a constitutional convention in which they were going to write a new constitution. At the convention, there were, as you might expect, different groups. The two primary factions were the Federalists and the Anti-Federalists. The Federalists, of course, arguing for a strong central government with enumerated powers, and the Anti-Federalists just said, wait a minute, we went through this King George thing, we don't want another strong central government. They fought. The Federalists prevailed. They had the Constitution. They sent it out to the states so the states could ratify it. The Anti-Federalists said, okay, they've gotten this out through the convention. It's in the hands of the states. What can we do to stop this? One smart guy said, well, I've been looking at this Constitution, and it has no protections for individual liberties, the things that even as Englishmen we enjoyed. There is no prohibition to keep the central government from forcing people to testify against themselves. There is no provision preventing the central government from housing troops in our homes. And there are no protections for expression. And the Anti-Federalists said, great, people want to be protected from a strong central government. And so they began a campaign in the states. And the campaign was, you want to vote for this Constitution, understand you're giving a lot of power to the central government, and you have no protections. Now the Federalists, for their part, said, well, this is a constitution of enumerated powers. That is to say, the Constitution gives the federal government powers, and where the Constitution is silent, the federal government has no power. So they said, of course the federal government has no power to regulate expression or to ensure that people can't be compelled to testify against themselves, because that's not in the Constitution. But people weren't convinced, and they said, we'll think about this, but we're concerned because even as English people we have these rights that don't seem to be protected by this Constitution. And it looked like the Constitution was not going to be ratified by the states that had to do so. So the Federalists reached out to the Anti-Federalists. They said, look, stop your campaign. We promise that we will write amendments to the Constitution providing for these protections that you say don't exist. And the Anti-Federalists said, deal. And they shook hands, and the Anti-Federalists didn't oppose the Constitution as much. It was ratified by the states. It took effect. This was the grand compromise over a Bill of Rights. They sat down, they started to hammer things out. You see from the PowerPoint screen that the First Amendment originally was the Third Amendment. Yes, all these public school teachers who told you that the First Amendment is so important that it is Amendment number 1, well, historically they're wrong. The first 2 amendments had to do with apportionment and also how much money members of Congress would be paid. But they dropped by the wayside, and so Amendment number 3 moved up to the first position and is the First Amendment that we know today. What does it say? What does it protect? What are the limits of the protections? Well, it's 47 words starting off with Congress shall make no law. And it follows that with respecting an establishment of religion or the free exercise thereof, or of liberty of speech or of the press, or of the right of the people peaceably to assemble to petition the government for a redress of grievances. What does it protect? Well, first it protects religion. The First Amendment says the federal government has no role in deciding what is the one true religion. And that's important because the history of Europe is filled with examples of governments killing people because they didn't belong to the one true religion. And the one true religion would change over time. It also protects us from religion. It keeps religion out of government. Yes, you can go to church, pray to whatever, or not go to church and not pray to whatever. That's fine, but the government cannot then say you have to pray or that you can't pray. Speech and the press, it protects us when we talk about things that can be controversial. It exists to protect the fringes of speech. It's a shield for those things that people write and say that a lot of other people say, well, that will lead to death and destruction. And that's one of the core values of the First Amendment. Because if we can protect speech that's on the edges, then speech at the core is safe. But it does have limitations. The First Amendment does not protect obscenity. Obscenity is a technical term we'll go over later. It allows for suits over libel and privacy. It protects a lot of expression, but in some cases it allows some prior restraints. And it constantly is changing. The justices of the Supreme Court from the 1800s would probably faint dead away if they saw some of the decisions by the more contemporary Supreme Courts and what it protects these days. How do we apply the First Amendment? Well, this is an important thing for the class. Think of the First Amendment in terms of a vehicle, a car. A car, the engine, unless you're driving an electric, relies upon internal combustion to create the power which moves the car forward. The First Amendment is internal combustion. The idea of internal combustion, and we have different sorts of internal combustion. We have diesel, we have rotary engines, but the First Amendment as internal combustion allows the car to move forward, and the First Amendment allows the law of mass media to move forward. But you have to be careful that you don't confuse internal combustion with the way the law applies to media or speech issues. Think of it this way. You get caught speeding. You tell the officer why you were speeding. So I was headed to a very important appointment with my doctor, or I needed to go to the bathroom, or I have a hot date. That's what you tell the officer. You don't tell the officer how the car is propelled by the process of internal combustion. So the officer, yes, I was going 90 miles an hour in a school zone, but I was going 90 miles an hour because of the four-cycle internal combustion engine in which, in the first stroke, called intake, fuel and air is drawn into the... No, you don't do that. Similarly, don't just toss out First Amendment in response to an issue of media or speech. Look for the specific law or the precedent, P-R-E-C-E-D-E-N-T, based upon the First Amendment to create your answer. And don't just say, well, so-and-so wins because of the First Amendment. That will get you 0 points. We'll pick up with the next video shortly.